Women in the Life and Law of the District of Columbia Circuit Courts, a program planned and developed by the Historical Society of the District of Columbia Circuit, with video produced by the Federal Judicial Center. Setting the stage and moderating the panel discussion is Barbara Babcock, Judge John Crown Professor of Law Emerita at Stanford University, and the author of Woman Lawyer, The Trials of Clara Foltz. Panelists are the Honorable Ruth Bader Ginsburg, Associate Justice of the U.S. Supreme Court and a judge of the U.S. Court of Appeals for the D.C. Circuit from 1980 until 1993. The Honorable Gladys Kessler, Senior Judge, U.S. District Court for the District of Columbia. The Honorable Royce C. Lamberth, Chief Judge, U.S. District Court for the District of Columbia. Nancy Mayer-Whittington, Clerk, U.S. District Court for the District of Columbia from 1991 until 2009. Michele A. Roberts, Skadden, Arps, Slate, Meagher, and Flom, LLP. The Honorable Patricia M. Wald, Judge, U.S. Court of Appeals for the D.C. Circuit from 1979 until 1999. And Helgi C. Walker, Wiley Rhine, LLP. And now an opening note from Stephen J. Pollack, President of the Historical Society of the District of Columbia Circuit.
Hello, everyone. Welcome to Women in the Life and Law of the Courts of the D.C. Circuit. I'm Steve Pollack. I'm President of the Historical Society of the D.C. Circuit. I'm your host. It's my pleasure to introduce to you today Professor Barbara Babcock, who will set the stage for our program and serve as moderator of the panel discussion. She's a natural for this assignment. She's one of the first 7 women appointed a law clerk to a D.C. Circuit judge, Judge Henry W. Edgerton. She was the first director of the Public Defender Service of the District of Columbia. She was the first woman appointed to the Stanford Law Faculty, the first woman on that faculty to hold an endowed chair, and one of the first anywhere to teach a course on women and the law. She's the author of a 2011 published Woman Lawyer, The Trials of Clara Foltz. Foltz, in turn, was the first woman admitted to practice in the state of California in 1878. Barbara Babcock knows the territory. Let's welcome her and begin.
Well, it's just an incredible honor and privilege to be here today in this courthouse on the very spot where I started my legal career 50 years ago. The invitation to be here originated when Pat Wald was being honored at Stanford, and I mentioned that I was writing my recollections and telling about the old days, and that gave her the idea of inviting me to moderate this panel. So one of my tasks today is to set the scene for our exploration of women in the life and law of the D.C. Circuit, which I thought I would do with some of these recollections. My first job as a lawyer was clerking in this building. The year was 1963. I had just graduated from Yale, where 3% of the students were women, and I never had a female professor. Indeed, I never met a woman lawyer until the summer I worked at Arnold, Fortis & Porter, as it was then. Carolyn Agger, Abe Fortis's wife, had been the first woman partner at Paul Weiss, and then she brought their entire D.C. tax department to Arnold, Fortis & Porter. She was a very impressive person, especially when she would smoke cigars. But she was not exactly, as an ace tax lawyer with a razor-sharp mind, a model for me who wanted to be a criminal defense lawyer and a law professor. I realized that a clerkship with a prestigious federal judge was a big plus for my ultimate goal of being a law professor. My plan had always been to return home to D.C., where I was born, to practice. And my native city not only had the legendary Warren Court, but right down the street was the Court of Appeals, with a number of judges as liberal and visionary as the best of the justices. Most attractive to me, common law crimes, rape, robbery, and murder, were tried in the district courts and appealed directly to the D.C. Circuit. A clerk on the court could count on criminal cases. I stood high in my class, and though not a law journal officer, I had published 2 pieces. Very confidently, I applied to Judges Bazelon, Wright, McGowan, Fahey, Robinson, but it never did occur to me that I would not obtain a position. The one I wanted most was Bazelon, because he was interested in criminal law and also regularly sent his clerks on to the very best Supreme Court justices. Alan Dershowitz, my friend and supporter, was currently clerking for Judge Bazelon. So one day when Alan called me, I thought he must have some good news for me, but with his inimitable directness, he said I did not have a chance. Not with Bazelon, not with anybody. But I said, I have interviews with everybody. Sure, he replied, but they won't be able to do it. They are not ready to hire a single, young, attractive woman. I was stunned and half disbelieving. Alan went on to say I should apply to Judge Henry Edgerton, a senior judge who still sat regularly and who had hired a woman in the past, one of the first and very few federal judges to do so. In fact, Alan had already made an appointment for me with Judge Edgerton when I came to see the others. I agreed to the interview, of course, while secretly betting that I would convince Judge Bazelon or one of the others to take me. But in case I misjudged my persuasive powers and charm, the Edgerton possibility would be insurance. He was the first interview on my schedule. At the end of an hour, the judge surprised me by offering the clerkship on the spot. I'm proud to say that I accepted immediately and didn't say, well, do you think I could meet the others first? And I'm often telling my students, be prepared. Don't apply to anybody you don't want to clerk for. But it was one of the best decisions I ever made. As a senior judge, Edgerton could designate the categories of cases he heard, though, of course, not the particular case. So when he learned of my interest, he decided to specialize for a year on the criminal side. And he also loaned my services to Judge Bazelon for criminal work. Judge Bazelon became my second mentor and was very helpful to my career at many points. The courthouse, as I'm sure it does today, had its own community. In 1963 and 64, there were very few women lawyers in this courthouse society. The only woman judge was Bernita Shelton Matthews, appointed to the district court by President Truman. There were no women on the Court of Appeals. 2 women were in the U.S. Attorney's Office, and Wendy Weinberg was a permanent aide to Judge Bazelon. I was the sole woman law clerk in the building. For a while, Judge Edgerton's clerkship became something of a haven for super women until things changed, and they changed almost overnight, and virtually all the judges take women law clerks on the same terms and equal competition with the men applicants. What changed, and it happened incredibly fast, given the conservative nature of our profession, is that the movement for women's liberation brought a surge in law school attendance. Almost overnight, it went from 3% of the nation's law students to 20%. As women's consciousness rose, men's applications declined because they could not obtain draft deferments for law school in a lot of places. Their increasing numbers and their liberation ideology emboldened the new women. They demanded female law professors, attention to their professional advancement, and coverage in every area of the curriculum, as well as their own course in Women and the Law. They did not accept the profession's hierarchies and try to assimilate, as my generation and all earlier ones had done. As related in my recollections, I can pinpoint the year that I became a feminist and joined the women's movement. It was not with me something that evolved slowly. In 1970, I was director of the Public Defender Service, and some of the Georgetown students who volunteered there convinced me to teach a seminar in Women and the Law. They had the syllabus for the course, which had been offered once before at NYU, but they could not interest anybody on the regular faculty in teaching it. When I said I didn't know anything about the subject, they replied, well, this would be a great way to learn. And they were a persuasive bunch, and I also felt that we owed them for all the free investigative work on our cases. I offered the course for only the second time in the country, and it attracted considerable press, in which I can hardly recognize myself in these quotes. In these, my pre-feminist days, I announced this is going to be a meat and potatoes course with the emphasis on remedies. Otherwise, a small seminar like this could easily deteriorate into talk about how we were forced to play with dolls as little girls and how it spoiled our lives. And a story in the Daily News describes me as hardly the classic woman's lib type. She is feminine, soft-spoken, and seemed to be wearing all her underwear. The students were right about learning by teaching, and though the field was new, there was a lot to learn. A movement had been growing up all around me, but I was so deeply involved in the issues of the indigent accused in my own personal life, I had not seen it before. That first syllabus given me by the students opened my eyes. We treated the woman and part of it literally. We examined the situation of women through the lens of constitutional law, criminal law, family law, probate law, employment law, and on through practically the entire curriculum. There were lots of cases and much to say. Somewhat to my surprise, having had no previous interest, I found that I enjoyed being on the forefront of a new field, teaching excited students who were invested in the success of the seminar because it was theirs. After only a few months, I began to think of myself as part of their movement, and that identification was to alter the course of my life. I taught at Georgetown in the fall of 1970, and in the spring, I offered the seminar at Yale, flying to New Haven from D.C. once a week in the late afternoon and returning early the following morning. At both Georgetown and Yale, I was impressed and amazed by these new women and their male allies, and willing to be their leader if they would show me the way. In an interview about teaching the course, I commented that the movement agitation has the law schools running scared. Schools such as Harvard, with no women on the faculty, are suddenly anxious to practice a little equality. Swiftly, it seemed that every law school wanted to hire one woman, and judging from the number of inquiries I received, I was that one. I had the added advantage that I came with a course and called Women in the Law. The women's movement carried me to two more firsts. The first woman, as you heard, on the Stanford Law faculty in 1972, and in 1977, one of the first women to be an Assistant Attorney General of the United States. Interviewers at the time often asked me some version of the same question. How does it feel to get your job because you're a woman? I developed a stock answer. It feels a lot better than not getting it because I'm a woman. Today, no one would be likely to ask such a question because women have come so far, so fast. Of course, we are still far from the equality goal when the sex of the person who argues the case or runs the agency is of no consequence, when the profession returns to its public interested aspirations, when it truly accommodates the lives of women and the needs of communal life. But this moment, here today, in this room, in a way that was not only impossible 50 years ago, but almost unimaginable. Everyone on the panel, and I would guess most in the audience, are part of this revolution, which is still in progress. So we should all be forgiven and encouraged and joined together if we celebrate ourselves and the grand evidence of progress this meeting represents. Now we have this wonderful panel of women and Judge Lamberth of great accomplishment. We'll call him the male ally, the token male ally. We'll go right to the questions. We'll start with Justice Ginsburg. And Justice Ginsburg, I'd like for you to, of course, say whatever you want to, but start with what you have observed in the participation of women in the justice system since you first became a judge on the D.C. Circuit in 1980.
Let me take you back to my first sitting on the bench of the D.C. Circuit. I think Judge Wald will remember this. There was Judge Roger Robb sitting in the middle, and Pat, I think you were to his left, and I was to his right. It was a complex environmental case, and Pat, who was exceedingly well prepared, asked some brilliant questions. And then after a while, I asked a question. And the response was, "Well, Judge Wald." You see, they knew that there was a woman on the D.C. Circuit, and she was Judge Wald. The idea of two was too much to contemplate. And what was the social scene like? Well, I was a newcomer to this town, and we went to various functions, and I was introduced as Judge Ginsburg. I'd say as often as not, a hand was extended to Marty, my husband. I remember very few women in the U.S. Attorney's Office in those days. The change, Barbara, as you have said, is enormous. There was a day, Pat, when you and Karen Henderson and I were together, and we said, we were three women judging, and nobody even noticed, which is as it should be. I was prepared after my 13 years here for what would happen at the Supreme Court, because sure enough, at the very first session in which I participated, I was called Justice O'Connor. Now, the National Association of Women anticipated this, so they held a reception, and they presented Justice O'Connor and me with T-shirts. And hers said, "I'm Sandra, not Ruth." I'm Ruth, not Sandra. Now, can I flash forward to how it is today? Given my seniority, I'm toward the middle of the bench. I have Justice Kagan on my left, Justice Sotomayor on my right. We are no longer one-at-a-time curiosities. We are all over the bench. My newest colleagues are no shrinking violets. The difference between having a lone woman, which it was a lonely position to be in, And having three of us is exhilarating for me, and it's the right picture for the children who troop in and out of the courtroom. People sometimes ask me, when will there be enough? And my answer is, when there are 9. And then people find that shocking. So given the changes I've seen, I am tremendously optimistic about the future for women and the law.
Thank you. Thank you. Now, Judge Wald, did you experience any difficulties in the courts of the circuit because you were a woman?
Well, it depends on what you mean by difficulties, but let me just say getting here was quite a chore. I was the first woman nominated to the U.S. Court of Appeals, and I had a controversial nomination. Maybe that's not so strange in itself, except I was told that I was anti-family. This is at a time when I had taken 10 years off to raise 5 children. So it was a bit of a bum rap. But then they also, on the other side of it, one of the senators who's long since gone referred to me as wild and woolly, which I thought. But having gotten here, I should say that I had practiced here both in the district court and in the Court of Appeals. A lot of the time, as Barbara mentioned, I was with legal services, and you'd get landlord-tenant law or family law, and you never won across the street. You had to go through the local courts. They're much different now. But at that period of time, you never won anything. So then you could take a writ of certiorari over here, and I can always remember the wonderful feeling about walking down those same steps between the local courts and the federal court and thinking, now I got a shot. In the early 70s, I had a lot of a big class action. It was but for poor women, indigent women, residents they wanted to send back to their home country, home states, rather than give them medical treatment here in the district. And so I had a great pro bono expert witness waiting down there, and I went into district court, and I got up and introduced myself, and I said, my name is Patricia Wald, and this judge, who shall go unnamed, long since gone, said, "What's your name?" And I thought, he may be one of the ones who's a little hard of hearing, so I upped the decimal level. And I said, "Patricia Wald." He said, "Tell me your name." And I thought, oh, God, what's going on here? And I said, I'm sorry, Your Honor, I think I'm misunderstanding. And he looked at me, he said, "Are you married?" And I said, "Yes, I am." And he said, "Then tell me your right name." So this, may have been aberrational, but I later found out that actually I read other people having somewhat, not just in this court, but in other courts, the experience. So, there were some back, but as Barbara mentioned, we sort of followed the same path. I was 10 years ahead of her, as it were. Yale Law School. I did clerk on the Second Circuit for one of the very few judges in 1951, Jerome Frank, who did take women. And then I was the first female associate at Arnold and Porter, but I made the terrible mistake, which was always put up as the reason you don't hire women, because I left within the first year to have a baby. So. But when I did get on to the difficulties, I was uniformly impressed by the very, very welcoming attitude toward me on the Court of Appeals. And that was true of the older judges and the judges who weren't, as my reputation was somewhat liberal, but the judges who came from possibly a different philosophical point of view, they were really extraordinarily nice. I can't remember of any kind of put-downs in becoming a judge. I will say the one thing I do remember, though, is that in the judge's robing room, there were 2 restrooms. And formally, because there were, at that time, 9 or 10 judges, the judges could share them. But Judge Tam, who was a gentleman of the old school, insisted when I came on the court that one should be marked ladies and one should be marked men, so that I had this restroom all to myself for a year until Ruth arrived. And all of the male judges had to line up for one judge. So if anything, it was affirmative action with a vengeance, I guess you might say. But I did feel that I was under more appraisal at the time that I was chief judge, because there are additional, as our male ally knows full well, there are a lot of duties that they don't put on paper when you become chief judge, a lot of responsibilities and a lot more opportunity over and above your case level to do things or not. Now, I like to think that when I became, with the help of the first woman chief executive we had, and we had a woman clerk of court, for the first time, we began to have women in the administrative, or made it a point to have women in the administrative. When I first came on the court, it was sort of a little bit like a king bee kind of thing. Lots of women in the offices, but the heads of the offices were all men. So that was one thing, and we set up dispute resolution, and we changed with the help of Judge Edwards. We changed a lot of the procedures of the court, and so we did attempt to, and I think successfully, to kind of bring it into the new era. There were challenges. I won't go into them here, but there's no question that I felt that the chief judgeship was more of a challenge being a woman than being a judge, which I'll end with my prescription for what I hope will happen. I hope there will be more, not just more women judges, which I do, but more women chief judges. By now, I think the majority of circuits have had at least one chief judge, not all of them. But I'd like to see a first woman chief justice, too.
We'll stay with the judges, and then we'll switch to the non-judicial opinions. So, Judge Lamberth?
Well, I was very fortunate. I came into the U.S. Attorney's Office in '74, so we're pretty far into the process, but not all that far, as Ruth points out. Judge Gash was the first judge to hire a woman assistant U.S. attorney. Judge Matthews, whose portrait is up here, and I became good friends during my time in the U.S. Attorney's Office because one of her law clerks was my mentor. I had two mentors in the U.S. Attorney's Office, but Ellen Lee Park was my mentor. And Ellen Lee had clerked for Judge Matthews for 6 years before she could get a job as a law clerk. And then she stayed as all this time as a law clerk. The first had been Sylvia Bacon, had been Judge Matthews' first clerk. And Sylvia had gone to the U.S. Attorney's Office. She's the first ever assistant U.S. attorney here. Ellen Lee was the second, and Patty Froman then was the third. Patty Froman actually clerked quite some years for Judge Matthews before the U.S. Attorney's Office hired her. So they were the trailblazers in the U.S. Attorney's Office. Ellen Lee was my mentor. Ellen Lee eventually was my deputy chief when I was chief of civil. She didn't want to be chief. She wanted to be my right hand, and we worked together as a terrific team. And I thought it was a very successful team because as women were becoming more aggressive, I hired one of the most aggressive, one of the most talented ever, a woman named Whitney Adams, and she decided to push the envelope. So she was the first woman lawyer to want to wear a male-looking pinstripe suit with pants to the court. And obviously this is made for friction. The male judges actually on the court weren't all that bad. It was the female judges that were a little worried about whether this was ahead of its time. And luckily for me, I had Ellen Lee Park who could go talk to the female judges and say this is the proper thing and the way to go, and my future lawyers all wanted to go this way and not be bound by the old Hyde ways of doing business among the male judges of the court. By the time I came along, I had Joyce Green and June Green and Norma Johnson. I had a raft of female judges I was arguing before. Once in a while, I was fortunate enough to have the two women on my right on a panel when I would argue the Court of Appeals, but I prayed not to have those two because they were tough. But so usually I only had one of them at a time when I was arguing appeals. But I think the progress of women is really demonstrated. Our clerk of court today is a woman. Our chief probation officer is a woman. I started a trial this morning that's going to go for weeks, murder, MS-13 murder type case. The lead prosecutor is a woman who made her opening today. The lead defense counsel is a woman. Both of them put me through my paces today. I think that we are seeing women really coming into their own now. And I think the trailblazers laid the right path, and we're continuing to see women really progress in our court at a very rapid pace.
Thank you. That's now, let's see. Judge Kessler, what do you think is the most significant change affecting women in the justice system that you have seen in your 19 years on the district court and 17 years on the superior court?
That sounds like such a long time. It's hard for me to imagine that I've been a judge that long. I came on the Superior Court bench in 1977. So I was sort of at the very tail end of the really difficult times that the very earliest women had coming on the bench and practicing law. I had come from a public interest law firm, and those were pretty unusual institutions at that time. Fortunately, not so now. I had done some practice in Superior Court, mostly rent strikes, and I had done very little practice in Federal District Court at that point. It's interesting, I've learned a couple of things just listening to my colleagues this afternoon. At the time that you were teaching women in the law with that NYU syllabus, I was teaching women at the law and the law at GW Law School with the same syllabus, mind you. And I would spend my Saturday nights reading the syllabus and all the cases in it so that I'd be prepared to deal with my class during the next week. And when I made the mistake one time of mentioning to my class that, I had read such and such a case on Saturday night, they looked at me as if I was crazy and said, "You were reading cases on Saturday night?" I said, "Yeah, sometimes you have to do that." When I came on in 77, there was only one other woman judge on Superior Court, a very competent woman who had been a former assistant U.S. attorney, who had really come through the hard days when women were treated terribly. And I think that had some impact on her. I didn't have some of the really terrible stories that you will hear from people, but certainly I was very much alone at the time. The fact that I had had a public interest practice, especially in Superior Court, nobody really had heard of it and couldn't quite understand what I did. And so I think I came with a fair amount of suspicion. Also, and times have changed so much about this, at the time I was appointed, I was considered very young. I guess the norm was for 50 to 60-year-old white males to get appointed to the Superior Court, and that would be the high point of their careers. So in addition to being a woman and having practiced in a world that they didn't understand at all, while I hadn't had trials in Federal District Court, I had done a lot of motions practice in this court, and that was different about me. And then, of course, as I say, I was a woman, and in the eyes of most of my colleagues, I was awfully young to be on the bench. That is not the case now, as you can see from all the women who sit on Superior Court and indeed in our own district court. As time moved on, there were enormous changes in Superior Court. And I am happy to say that many, many women came on that court slowly, though, very slowly. And at this point, I don't think there's any question at all about the numbers over there. I don't think anybody even keeps count of the numbers anymore. I do believe firmly that there were many changes that went on in Superior Court because of the influx of women judges on the bench. There were dramatic improvements in how we handled cases as important as domestic violence, as child support. There was new federal legislation that required all the states, including the District of Columbia, everybody, to develop child support guidelines. Nobody ever talks about those guidelines but they made an enormous difference in the ability of parents to take care of their children because we saw so many single parents, mostly women, but not all women by any means. We worked on alternative dispute resolution, and we started the first project that was really a model project of the ABA to develop the courthouse dispute resolution program. So that I saw a lot of changes. In terms of the actual practice, though, I agree with Judge Lamberth that you saw lots of women coming into the practice of criminal law. In particular, lots of women coming into government positions. And they were good, and they were very well trained, and they were self-confident, and they knew what they were doing. You found some women lawyers on the defense side, but as you know, Public Defender was a small organization at that time, and while its women lawyers and its male lawyers were superb, there weren't all that many of them going around. And then there were some women in the CJA system who were practicing, but not a lot. The real problem that exists to this day is you do not see women in court in the big, money-making civil cases. You still don't see them. You might see them sitting at the table, especially if the lawyers know that their case is being handled by a female judge. They'll get it together to pick out somebody in the law firm who looks like a woman and can sit at the end of the table. And occasionally I comment on that, but I know that I shouldn't, and so I try not to. But I think the lawyers understand. But it is a rare time in a big civil case that you see someone. I have a super-duper lawyer in a big civil case right now who is a woman, who knows exactly what she's doing, is very, very skilled. But again, you just don't see them in civil practice. And I mean, that gets to changes that we'd all like to see, and I think that's a subject you want to move on to a little bit later.
So let's stay with the courts, and then we'll finish with our two practitioners. So Nancy Mayer-Whittington, what challenges have women faced in pursuing leadership positions in court administration in the D.C. Circuit?
There were challenges all across the board. When I began my career at the courthouse, my passion became leveling the playing field for women who chose non-judicial leadership positions. When I came to the district court in 1977, I was a recent college graduate, empowered by my education and my women's history courses, and ready to move mountains. I soon learned that while the mountains were the most visible challenges to my career, the molehills were the toughest and most entrenched barriers to success. At my first clerk's office meeting, one of the mountains was front and center. Although the office was 80% female, the management staff was 100% male. No role models of women who had successfully navigated the career ladder. As I tried to understand the culture of the court, it became apparent that the judges greatly influenced the operation of the clerk's office. The court had recently moved from a master calendar to an individual calendar, so the judges became their own CEOs. And when I say CEOs, it was CEO across the board. The court had 15 active judges, 6 senior judges, and only 2 of them were women. As we've heard, Judge Matthews was appointed in 1950 and had taken senior status in 1968. And in 1968, Judge June Green was appointed and was still an active judge. But the potential for role models among the judges was also very limited. I worked throughout my career to make the administrative side of the court family-friendly. I was especially concerned with women who had families, and of course that included all women. While it's true that not all women had a spouse and or children, every woman had a family, parents, siblings, extended family. And as the primary caregivers, they had to balance their desires for a fulfilling career with the desires and responsibilities to care for their families. That was certainly true back then, and if current data is correct, women still bear the primary responsibility for child care and elder care. There were so many challenges that were buried in institutional policies, the molehills, that it seemed like everywhere you turned, there was another stumbling block for women. For example, the only real career path in the clerk's office was through the intake section to the docket section to become the prized courtroom deputy. But I'd gotten to know most of the courtroom deputies through my work in the jury office at that time, and it was surprising to me that most of the women, all of the women actually in the courtroom division, were single. Some divorced, some never married. They had very little family and no young children. When I sat in on an interview for new courtroom deputies, I found out why. The question they were using had been in place for about 15 years. And the last question, the mega question, went something like this. It's 5 o'clock on Christmas Eve. You've just gotten out of court. You're on the 15th day of a long trial and are packing up to go home. Then you're told that a TRO has been filed and your judge drew the case. You've not finished your shopping for your young children and the stores close at 9 o'clock. What do? They gave you choices. A, you look around the office and see if you can get someone to cover for you. B, you go to the judge and let him know your situation and see if he'll help you find some coverage. Or C, you go to his courtroom, you cover the TRO, and you never let the judge know about your dilemma. Now I'm sitting here going, pick A, that's the best one. It shows your innovation and your resourcefulness. You're trying to solve the problem, great. Or pick B, it shows you have good communication skills and you have a good rapport with your judges. The person being interviewed said, honestly, I would try to find someone to cover for me, or I might approach the judge and let him know my situation. I looked over at the interview panel, and they're all making this big red X through the last response. They thanked her for her time, and the interview was over. I asked them what was wrong with her answer, since I thought it meant she was trying to use her intelligence to find a solution. The person who was the head of the panel told me they're not looking to hire courtroom deputies who have distractions. He went on to say that he didn't need a courtroom deputy who could think. He needed ones that could just do what the judge needed them to do. This was just one example of policy barriers, and there's so many more. If you continue with the molehill analogy, the policies that made advancement challenging for women were like that game you find in the arcade, the whack-a-mole. They just kept popping up everywhere, and it was everything you could do to try to knock them down and to change them. The time and attendance policies that did not allow for any flexibility in arriving and departing, something that was especially difficult for women who were working with schedules other than their own, the sick leave policies that did not allow you to use sick leave to care for a family member, even the prohibition of the use of the office telephones for personal matters. Women needed to make sure that the kids got home from school safely or that their elderly mom had taken her breakfast and her medicine in the morning. Violations of these policies resulted in points being counted against you and used against you and your ability to advance. I could go on, but I will conclude with a personal example. When I was interviewed in 1990 for the position of clerk of court, I couldn't help but reflect on the progress that we'd made. I prepared thoroughly for this interview, and I thought I was ready for any question that any of the judges threw at me. The first question from Judge Revercombe, who I liked very well and who was a wonderful judge, went something like this. So, your full name is Nancy Mayer-Whittington. 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 Do you use this on all your credit cards? I said, yes. He said, is it on your driver's license? And I said, oh, yes, it's on my driver's license. And he says, is it even on your bank accounts? At that point, I didn't know what else to say, and Judge Aubrey Robinson, who was chief judge and head of the panel, said, for God's sakes, George, I think we've established that's her name. If you don't have any substantive questions, could we move on? And you know, he didn't ask me another question. So despite a lot of years of hard work, he just couldn't get past my hyphenated name. So there was still much work to do. And those are just some of the challenges that we faced for women who are trying to pursue leadership positions in court administration.
Thank you. Yeah, I think I'll go to you next, Michele, because the question I'm going to ask Helgi is one that others may want to answer too. What were the critical requirements for you in becoming a first-rank trial attorney? Do you see them as being different from those that would be required of a man?
I would say a thick skin. I had wanted to be a lawyer and wanted to be a trial lawyer for as long as I can remember, and believed that the challenge was simply finding a way to pay for college and then get through law school and then, God forbid, the bar exam. So having done all of that and been fully trained by the Public Defender Service, when I walked into court, I assumed that I would receive instant credibility. I mean, I had arrived. And so when I was greeted with this, frankly, a presumption of incompetence, I was taken aback by that. Now, I got over it very quickly based on something that you said, Professor Babcock, and that is I remembered that the first trial lawyer that I had seen that looked like me, I didn't see until I was a third-year law student. And so I reminded myself of that and said, these people that are treating you like something other than a lawyer maybe haven't seen anything like you before either. And so, I did have to deal with other attorneys who frankly didn't take me seriously, who thought, my opponents, that I would be an easy mark. I had to contend with judges and there were just a few judges on the Superior Court, which is where I grew up, who were women, but many of them, again, seeing me, and by the way, I'm black, so that was that was a bit of an added complication. Didn't necessarily take me too seriously. I can't tell you how many times I was in a courtroom and a clerk would ask if I was looking for my lawyer. Jurors would be amused with me, and you could see them smiling and think, oh, that's a lawyer, and I wondered if they would take me seriously. What was most painful, though, were the clients. Again, I started as a public defender, and they had no choice. They had to take me. And it was not unusual to have a client be visibly upset when I would introduce myself as their attorney. They wanted a guy. They probably wanted a white guy. And they assumed not only was I a free lawyer, but I was a woman, and a black woman, God forbid, and probably no good. So, my choice was to be paralyzed by the fact that people weren't taking me seriously. And that was something, frankly, I'd seen a lot of women, a lot of black women, a lot of black lawyers, a lot of lawyers of color do spend a lot of time bemoaning the fact that they weren't taken seriously. Well, I assumed I didn't have time for that because I had clients who, if I didn't win, and win is always in quotes, they were going to prison. And I suspected that rather than have me go home at night and cry and lament and worry and wonder and pray for justice, they wanted me to prepare for trial. So that's what I did. I worked very, very hard. I tried to imagine my opponents asleep, and I'd be up working. And the way that I sort of demonstrated that, yes, a black woman could be a really good lawyer was by being a really good lawyer. So I just didn't have the luxury of time. I had the luxury of those women who came before me who at least set the table. And then I had clients who frankly didn't have time for me to lament. And so I just did what I was being paid, not much at the time, to do. And I tried to do it well and be the best lawyer in the room. Frankly, I eventually learned to enjoy the presumption of incompetence because that meant that indeed my opponent was asleep at 8 o'clock, right? And that meant my opponent did think he didn't have to work as hard to defend against me, right? And that judge did find herself delighted to learn, wow, that's a real lawyer in my courtroom. And juries learned to love me. They loved rooting for the girl. And so, I don't have a problem if I meet a lawyer now that has that issue. I just quietly smile and realize that he's going to get a good night's sleep tonight. And in the morning, ... and dot.
And then finally, on this round, Helgi Walker, Who were the most important influences for you in your legal career, and maybe particularly women, but generally?
Thank you. Well, I'm going to take your lead and not answer that initially, at least. I just want to say that I feel my role on the panel, looking around, is really a generational one. I'm here because I practice appellate law in this circuit, which I love doing, but I grew up in a legal culture and at a time when I did not have to face the things that so many of the women on this panel have talked about. And for that, I'm deeply grateful. I understand that in that sense, I've led a charmed professional life. I just have never had somebody say those kinds of, frankly, shocking things to me. As Justice Ginsburg said, it really should be of no consequence whether your lawyer is a woman or your judge is a woman or whether the Attorney General of the United States is a woman. Sometimes, even for my generation, though, it is of consequence. Just the other day, we were on a conference call with other lawyers and clients being read into a very important case where there had already been one round of arguments. And one of my future co-counsel said on the call, well, it was just the most bizarre thing. We had a panel of 3 women in this federal circuit, and, went on then to describe the rest of the argument, and then it was my turn, and I said, golly, I know just how you feel. Last week, I had an argument in the D.C. circuit, and I had 3 men on the panel. It was so unsettling. The line was quiet for a little bit, but every now and then you have to stick up for yourself a little bit, and thanks to women like the women here, I am in a position where I can do that. And now getting to your question, Professor, in light of, I think, the shift of how far our legal culture has come since you all started out, the question of the influences on women and the people who can point out to you the possibilities for your career, I think, have taken a significant change. My father just retired as a law professor at the University of Virginia and was a practicing lawyer when I was very small. And he has studied a lot of social science and law. And so I thought, well, I'll look at the social science on this question. And a research psychologist at Cornell Medical School named Peggy Drexler has done an extensive study of hundreds of very successful women, whether they're CEOs or law firm managing partners and such. And what she's found for my generation is that the father-daughter relationship for these women is a consistent theme in how they feel they got to where they are and who it was that very originally gave them the confidence to think of themselves as a person, an intelligent being who could do anything that anybody else in the room could do. So I think that's kind of some interesting data on that. My own father, who is actually quite a traditional person, used to say that the quickest way to reform a male chauvinist was to give an ambitious man a daughter. It turns out that the social science supports this as well. A professor, Dan Brill, at Columbia Business School recently came out with a study that showed that when a male CEO has a daughter, particularly a first daughter, the relative pay of the women in the organization goes up. And, we laugh and we kind of understand that intuitively, but this study has a very large and serious empirical basis to it. So I've always found that interesting. So for me, my most important person, the biggest influence on me was my own father, so not a woman. Of course, there have been fabulous women I've worked with and had as law professors, but in this day and age when we can see ourselves in different ways and when men can see their own daughters in different ways, maybe at this kind of transition period, that's, I think, as interesting and as fruitful an area for ways to keep making progress as almost anything else. So if there are ambitious men in the audience with daughters, talk to them about what you're working on. Don't necessarily ask them about their dolls. Read The Economist with them and so forth. But for my generation, it's been so much easier thanks to so many of these women here today.
Would anybody in the panel like to talk about your role models or forebears? At this point, it wasn't scheduled.
I have to tell one story because I can't be in this courtroom and not tell it. Judge Matthews, as I said, really became very friendly with me. Part of it was I was handling all the White House administration cases at the time, and she was fascinated by what I did in the U.S. Attorney's Office in connection with the demonstrations because she had been a suffragette. She had marched on the White House sidewalk for the right to vote for women in the 20s. And she told me about how when she marched, she zipped her lip because if you spoke a word, they would arrest you for demonstrating without a permit. So she knew to keep her lip zipped as she marched up and down the sidewalk. She had the most wonderful stories, but the one story I have to share for this kind of a program is when she got out of law school, she grew up in Mississippi. She went to National Law School, which became GW. Nobody would let a woman litigate, so she had to do real estate law. Nobody wanted women in the courtroom at her time. She just couldn't make an inroad there. But she did the most wonderful thing as a real estate lawyer. William Howard Taft had been president, and he became attorney general, and he decided the Supreme Court should no longer sit in the Capitol. They should have their own building. And he decided where he wanted the building, which is where it is today. Unfortunately for him, the Women's Democratic Club was on that particular spot, and she, as counsel for the Women's Democratic Club, drove such a bargain for him to get that space that she raised enough money that the Women's Democratic Club today is still operating on the funds from the sale of that space to the Supreme Court. That's the story she told me. Now, you may know more about that.
It was the National Woman's Party.
Yes.
And Bernita Shelton Matthews was the counsel to that party when Alice Paul headed it. The house that they swapped when they left the Capitol, when they left the Supreme Court site, is Sewell Belmont House. And today it's kind of a museum. But the National Women's Party was the group that wouldn't settle for the vote. They said they wanted women to have it all, and so they introduced the Equal Rights Amendment in 1923 for the first time. Wow. Every year after. When I came to the D.C. Circuit, Bernita Shelton Matthews was still alive. She was in her 90s. She could not hear that well or see that well. But I met with her many times just to hear her wonderful stories, and one of them is about holding up her sign, votes for women, but not speaking a word. What did she do when the Supreme Court was to be built on the site of the National Women's Party? Well, she was not taken very seriously. And the counsel for the government said, oh, it's just a ramshackle old building. It's not worth very much. Bernita Shelton Matthews found a member of the older inhabitants of D.C. who said, I know I was there when this building was a prison for Confederate spies. Before that, Bernita Shelton Matthews established, it had been the temporary capital when the Capitol was burned in the War of 1812. But her pièce de résistance was she had a photograph of a notorious Southern spy who happened to be a woman inside that building. Oh, that's great. And she won, in that case, it was the largest condemnation award that the government had ever paid up until that time. She hired only women law clerks because the others hired only men, and she got by far the better of the bargain.
These stories remind me of something. When I first came on the court, I was told that one of the judges had commented to other judges during my confirmation in the judge's dining room. They said, well, she seems like a pretty nice woman, but, with that experience, wouldn't she be better on a juvenile court than on the Court of Appeals? But what it did invoke in me was knowing that the D.C. Circuit, which was known as the big administrative law circuit, or at least as the clerks called it, the planes and trains circuit. So the first chance I got, I said, where would you go to get the most concentrated knowledge about technological stuff going on in the FCC or the FERC or any of these agencies which come before us? And they said, well, there's this school which is like 12 hours a day, 7 days a week for 2 weeks out in not the University of Michigan, but Michigan State out in Lansing, that they send all the new utility commissioners to from the states. And I said, well, could I get a scholarship out there? And so Leo Levin, I think, was on that. He said, well, nobody's ever asked before, but he said, I'll find out. So I did. So I went out for 2 weeks and, just went through this concentrated thing. It's not that I remembered everything, but when I went back in the courtroom, I recognized the jargon, and I did not feel overwhelmed by it. But, of course, I ended up writing an enormous number of FERC opinions, such that the joke among my clerks was, give her a share of El Paso natural gas for Christmas so we can get recused from them all.
How has your gender, if I guess we call it these days, affected your job? And then for you, Judge Lamberth, why don't you start? And how did you observe the gender of the judge or the lawyer making a difference?
I really don't think that judges act any differently in terms of how they decide cases, and I don't see that distinction. I do think Judge Kessler is right about in heavy-hitting civil cases, you do not see senior partners as women doing those kinds of cases, and so there's still a glass ceiling somewhere. We're not really seeing it among the judges. We've been very fortunate as a country that we really have a number of distinguished women judges and role models, as we have here today, to lead the way for women as judges. So I don't see that distinction. I do see that there's a disparity in law firms and in practice generally, that women are still having a hard time with that glass ceiling.
I'm working on that, Judge.
I know you are.
And with some success. I mean, I will say that just yesterday I spent the day in a joint defense meeting with, I think there were 8 law firms there. And I can tell you that the lawyers who are most vocal and are probably going to lead that case are 2 women, and you're looking at one of them. So we're working on it. But it does come from clients who are now who are more amenable. I mean, there are a lot of in-house lawyers that are women, and they are controlling a huge amount of legal spend. And my colleagues, my male colleagues may not like it, but they sort of like it when I walk in the room and during a pitch. So it is a problem, and we've still got a good ways to go, but I think you're going to notice more and more people, more and more women who are heading those cases. We're working on it.
I think in the state system, there are more things attached to being a woman judge. For example, I'll use Superior Court just because I know it so well, but I know a lot of women judges around the country, especially in the state systems. And when a woman comes on, I think she is still, not as badly as when I started, but still scrutinized very, very carefully. And I think that exists in the federal system, but to a more minor extent. One of the key things that the public looks at, when I say the public, I shouldn't say that, the bar looks at is, how well do you really control your courtroom? In the state courts that are so crowded and have so many cases scheduled every day, it takes a real skill, which of course you've never learned before you became a judge, as to how to keep 50 or 100 cases moving and get them done by the end of the day without acting like Attila the Hun. And I think there's a real concern until you prove yourself as to whether you can manage a courtroom. I think that people scrutinize your demeanor in a very odd way. I mean, I'll give two examples. A local publication did an evaluation of certain judges, and one female judge was criticized because she never smiled in court. Can you imagine making that comment about a male judge? I mean, that's just ridiculous. So I think that a woman judge, when she comes on, has to prove herself in terms of handling the docket, in terms of being able to manage a pleasant and civil courtroom at the same time that you're handling that docket. I think that women judges who are as heavy-handed as some male judges are far more criticized for taking that kind of attitude in the courtroom, even though if they didn't take that attitude, nothing will get done in the course of a day. So I think there are real differences even for a judge once she gets on the bench.
Do you have anything to add to that, Justice Ginsburg?
Well, go back to the bad old days, the 70s. This is a typical case, appellate argument. I was appearing before 3 judges. It was a 3-judge district court in New Jersey. And one of the judges commented, well, I think women have it okay nowadays. Even in the military, there's equal opportunity. And I said, Your Honor, they still don't give flight training to women. His response, oh, my dear, don't tell me that. Women have been in the air for years. I know from experience with my own wife and daughter. So what do you say? You don't say, you chauvinist pig. Because your object is right there in front of you. You want to win the case. So you blurt out something like, yes, Your Honor, and I know many men who don't have their feet planted firmly on the ground, and then go on. One more story in that line. It was my very last argument in the Supreme Court. It was 1978, and my later boss, then Justice Rehnquist, this was a case about putting women on juries. The young women here probably are not aware that for a good part of the last century, women were either automatically exempt from jury service, not put on the rolls at all, or they could opt out for any reason or no reason. So this was a case about the state of Missouri that still had the automatic opt-out system. I thought I said what I needed to say. I was about to sit down when Justice Rehnquist said, and so you won't be satisfied with Susan B. Anthony's face on the new dollar. But that kind of humor, it was long recognized that you do not make jokes about race, about religion. It was still thought okay to speak about women in an unflattering way. Now, fast forward to 1993. Justice Rehnquist is now the chief. The Attorney General of the United States is Janet Reno. She doesn't want to be called general, as most attorneys general do. She wants to be called Ms. Reno. I don't think the old chief was accustomed to Ms. So we had a kind of a dress rehearsal. He said, Ms. Reno, Ms. Reno, Ms. Reno, till he felt that he would be comfortable the next morning. So that is just one sign, Barbara, of the exhilarating change.
As many of you know, after I left the D.C. Circuit, I spent 2 years abroad in The Hague and International Court. But I ran into so many of the same problems, but coming at it, from it, when you sit on a court that's got people from many different countries and many different civilizations. And some of them this was the late 90s and early 2000s, but some of them, I have to say, actually acted like the stories we're hearing about in the 70s. I mean, one of them there was one judge from Egypt, and when somebody, one of the women deputies, she actually was an African-American woman, clerk deputy or something, and she was wearing a black robe as the courtroom deputies did like that, and he'd say to her, she went in, he'd say, "You should be wearing an all-white robe and going down the aisle, not going into into this courtroom." But my law clerk, who is here today, actually, because she's now one of the best prosecutors at the ICT1, and she's over here with the chief prosecutor. And I do think that one of the most important things here, and it turned out to be, I think, for the international courts, is the clerkship route. I mean, to get women in these clerkships. Now, I think half of my clerks during my 20 years on the circuit were women. I know a great many of Justice Ginsburg's were when she was on the court here. And it just isn't, that was the way I got. It opened so many doors for me when I was young. And it is a kind of a certificate, that you can do the job and that you know all facets of the job. And that same kind of process is going on abroad in the international courts, even though many of those judges, come from places where women don't have the ordinary privileges that we expect in everyday life. And so there's a big learning role to be learned there. But hopefully that too will come with time.
There was one time where my gender in a professional context mattered, to answer your question, but it mattered not so much for me, but for some of the other people that were involved. I was working in the White House counsel's office, and we're working on judicial nominations, and we had been scouring a particular state for some really well-qualified people to sit on a federal district court in a rural district of a state far, far away from here that I won't name. And I was talking to one of our contacts in that state who had called me when they, as these rumors go around, heard who maybe was under consideration for a federal judgeship. Miss Walker, you don't understand. You cannot put a woman on the federal district court in this district. The bar will simply not accept it. Well, to my earlier point, I had actually never heard a person speak like this, and I was so shocked that I really didn't know what to say. So I didn't say anything to that person. I said, "I understand, and thank you for your opinion." To my also earlier point about the transition that we've seen, that person made a very big mistake when they said that to me. I was in a position where I had a job of some influence, and the people that I was working for had an attitude, a cultural background where they found that sort of statement as troublesome as I did. And on top of that, I was really mad. So when I reported this to my superiors in the White House, they were as shocked as I was, and the person we'd identified was an amazing lawyer. We were frankly fortunate to have a candidate like that in this area. And as it ultimately turned out, the fact that we had gotten this kind of feedback from some people in the state made the people that I was working with in the White House counsel's office and ultimately the people who make the nominations even more determined that, yes, we were going to put a woman on the federal court in that district, and she's there now, and she's doing a really great job. So that's my war story from my position as to a particular situation in which gender mattered. And I think the serious point there, though, is that we now have a culture that where when comments like that are made, there can be a backlash against it, and it can turn out to be a very harmful thing for people to dare to make a comment like that or to think that that's an okay thing to say. Those people are not the people who get their way in at least certain legal environments anymore, and so I'm happy that we have a great woman judge on the bench in that district now.
How about you, Nancy?
I actually thought it was an advantage being a woman in the district court. My predecessor was a male, clearly, and at times I think in his working with some of our judges there was a little bit of not a power struggle, but sometimes a little bit of an ego that got involved, clearly on the part of the judges, but also then on his part too. And I felt like when I came on board and tried a different tack with working with the judges, that had a much more success rate in communicating things, and also then in helping to develop our female staff, because the judges felt like they were empowered with information, and I shared things, and so I frankly thought it was an advantage.
I think I tend to agree. I mean, because my work is so personal, I don't want anyone to hire me that doesn't want to hire me. You know what I mean? I don't need that crap. So if you think I'm incompetent, then fine. Who's your opponent? I'll get that representation. So I know there are clients that have not hired me because I'm a woman. I know it. I mean, I have gone to beauty contests and I've seen people be enamored with a lawyer who was 1/10 as talented as I was, but he was a he. And I've walked out of there saying, well, that's your loss. I don't spend time with it. I think most of the time I am finding myself advantaged because I'm a woman. Again, there is a lovely surprise that people seem to have when they see a competent woman. I mean, and those of us who practice law, we've seen jurors actively rooting for us because they like seeing us go toe-to-toe with the boy. I've frankly gotten some cases because the judge was a woman, and that works for me too. So I think that it's probably not as much of a wash as I tell myself, but again, I am delighted I'm a woman, and I don't spend 1 second saying it's not fair.
Yes, Gladys.
I think before we close that we ought to give some consideration to an issue that I find very disturbing. And I think it's an area in which the women's movement has not been at all successful. I think ultimately, if we're to keep women in the profession, whether they go out for a short while to have kids or whether they don't, it doesn't matter, that if we don't think seriously about restructuring the profession so that it becomes a livable profession for men as well as women, that women are going to continue to flee the way the numbers show they are fleeing now. I don't know what the men will do. I do know from talking to my male law clerks that they are very aware of these issues, that they want more private time, that family is important to them, and that while they are forced to go into the big law firms and earn a lot of money to pay off their incredible unfair debts for law school, once those debts are paid off, their long-term plans are to get out of that world and practice law in a very different way. I don't hear us talking much about thinking through fundamental institutional change in the profession. And while, yes, most of us, well, I don't know about most, many of us are getting treated pretty decently these days, I don't think that we have reached the end of the road by any means in terms of perfecting our profession.
I think, and that really fits right into our last question of the day, which is what steps remain to be taken. And I think that the women's movement does have to turn. Up until now, we've been trying to get in. To get in, to assimilate, to be accepted, but now we've got to try to change the profession. And when you think there's almost 300,000 women lawyers and hundreds of thousands of male allies who want these same goals, we can change the profession. We can make it change, and in this way that it becomes a profession again, and not a bottom line business in all regards. And this idea that there's too many lawyers, well, there are not enough public defenders, and there's not enough lawyers for the middle class and poor people. And there's just a tremendous amount that can be done and room, but we have to. There's lots of steps that can be taken, I think, and the women now that I'm sort of for declaring victory on the on the equality. I think we really have come a long way, and it's we want to celebrate that. But now we have to go on and change this profession, which is resistant. Now that we have the numbers, that's what I think. But you all, please add.
Well, I do, Gladys. I agree with you, but I don't think that the women's movement has done nothing or had no influence. Let me give you just one snapshot. When I was a student at Columbia Law School, and my daughter was between 3 and 4, there was only one place in the neighborhood, only one nursery school. They took care of a child for half a day, so he could go 9 to 12 or 2 to 5. My daughter, the next generation, she's a professor at Columbia Law School. When she came there, she was given a list of at least 20 full-time, full-day daycare in the neighborhood. So things have changed. Another example is when I came to the Columbia faculty, there was a benefit for college education. You got full tuition at Columbia, half tuition anyplace else. My first comment was, what are you doing about nursery school, about grade school? If you want to attract good young faculty, then that's where you should be putting your money. Looking at the way things have changed for women at the court, I don't know what Helgi's experience was, but I have had women with, I think almost every one of my colleagues have had women with children. I had, a couple of terms ago, a woman with 2 children under the age of 3. She was able to manage that job so that I never felt in the least advantaged. Sometimes she worked from home. Of course, the trick is she had a man, she was married to a man who thought her work was as important as his. So I think if men appreciate that one day they're going to wake up and the kids are all grown and they had such a small part in it, it is changing. I see my son's life and my daughter's husband and their attitudes. Not fast enough, but I think it is going in the right direction.
Pat Wald has always been, from an early age, my heroine on this score of how to manage both. Why don't you describe your life with 5 children?
Well, I think the secret is to pick a partner, who shares your values. I can remember writing briefs up in the Library of Congress on Sundays because I had no office, while he took all 5 kids out and somehow managed to get through the day with them. I don't think we've come far enough along because in some of the really big law firms, the really powerful law firms, they do want to own those young associates. They get the big case and the big client, and they want results, and they want that 18 hours a day, et cetera. So somehow, until you break through that, you can break the glass ceiling, but you also got to break this ceiling that somehow, you've got to be 100% in those early years there. As I keep saying, and especially if law firms or senior partners or whoever managing partners can understand that if you hire a talented woman or man out of law school, they're going to have, with luck, something like 40 to 50 years of their career ahead of them. And do they have to become a partner in so many years, or do they have to do so many hours in those early years? It is possible to figure out a structure, as you suggested, that allows people to, we all know. I mean, I always felt one of the great joys of judging, actually, is you could manage your own time, and you found that, I'll be honest with you, it was not the hardest job I ever had. I mean, because you could manage your own time, and you could work very hard, but there was time to do it.
It's so hard now. One of the things I think we need to work on is making it more possible to re-enter, to leave and to get back in. It's so hard to get back in now. And that's one of the things, that's part of your story, Pat, as I tell it, which is that you didn't just take off to raise your children and then go back in, but you kept your hand in.
Well,
but not at a regular job.
Not really.
I saw you doing it.
I was really out of it for 7 years, but the thing was I was lucky because I moved in legal circles, and I had a lot of my friends I went to law school with. So, when in the Bobby Kennedy Justice Department in the early 60s, he gave me and other people a consultant contract, and so I would, work until the kindergarten got out and run in a cab and be home by the time the kid got home from school.
I know that we used to say at the beginning of the movement that the personal is political, which I just think is the most wonderful slogan, and this is an illustration of that today. And the other thing we used to say is consciousness raising is our method, and but sitting around and talking and answering questions and telling our stories, I do think is a great thing to do, and is a part of our movement. And I want to thank the panel very much. I've really enjoyed listening to you and being with you today, and what a wonderful panel.
Thank you so much, Justice Ginsburg, judges, lawyers, administrators. Everyone on our panel has a direct, active connection with the courts of this circuit. So we're privileged to have their comments. Grateful for you coming. Barbara Babcock, thank you so much for being our stage setter and moderator. Thanks for coming. You're our biggest audience. We give you a hand.